we'll take care, if we can, if we have the attorney, we'll take care of the next plea as well, and then we'll go to the bond hearings.
We have Mr. Huffman here for Anthony Valdez.
Okay, so good afternoon. This is Judge Elisa Perez presiding over the 210th District Court criminal docket for January 21st, 2025. All matters being heard today are being heard in accordance with all emergency orders and directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Hernandez, would you call our next case, please?
Yes, ma'am. Calling cause number 2024-0D06101, State of Texas versus Leopoldo Areola. Announcements, please.
Good afternoon, Jose Garcia for the state, present and ready.
Good afternoon, Attorney Elia Garcia, on behalf of Mr. Ariola, we are ready, Your Honor.
Good afternoon, counsel, and for purposes of the record, Mr. Areola is appearing remotely from the jail annex. Mr. Areola, I have you scheduled for a plea today, and I did receive a written consent that appears to be signed by you in order to conduct this plea on Zoom rather than in person. Did you have that agreement to do this via Zoom?
Yes, Your Honor.
Okay, to get started with your plea, I do need to swear you in. Please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you. You can put your hand down. Sir, would you please state your name and date of birth for the record?
Leopoldo Ariola, August 3rd, 1995.
Mr. Areola, as I mentioned, I did receive documents from your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Areola, do you recall reviewing State's Exhibit Number 1 with your attorney before you signed that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes, Your Honor.
Ms. Garcia, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, Your Honor.
Mr. Areola, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
Ms. Garcia, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Areola, have you ever been found mentally incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Oh, no, Your Honor.
So based on your testimony, your attorney's representation, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Right here in El Paso,
Texas?
Paso, Texas. Yes.
Okay. In this case, you were charged with the offense of theft of property in an amount between $2,500 and $30,000 to that charge. What is your plea, guilty or not guilty?
I'm guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Mr. Garcia, would you summarize the evidence, please?
Yes, Your Honor. Had the state of Texas proceeded to trial, the state would have shown beyond a reasonable doubt that on or about the 30th day of July, 2024, in the county of El Paso, state of Texas, Leopoldo Arreola did unlawfully appropriate by acquiring and otherwise exercising control over property other than real property, to wit, a Pontiac motor vehicle of value of $2,500 or more or less than $30,000, without the effective consent of the owner, namely Marta Gonzalez, with intent to deprive said owner of said property. Your Honor, the state would like to offer into evidence States 1, the plea agreement, and States 2, Article 3914.
Any objection?
Objection, Your Honor.
Without objection, States 1 and 2 are admitted. What is the plea agreement?
Yes, Your Honor, the plea agreement is pursuant to Article 1244A, credit for all time served.
Is that your understanding of the plea agreement, Ms. Garcia?
Yes, Your Honor.
And Mr. Areola, is that your understanding of the plea agreement?
Yes, Your Honor.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled The Trial Court Certification of Your Right to Appeal. It's a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Areola, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of theft of property in an amount between $2,500 and $30,000, and I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 127 days confinement. El Paso County Detention Facility. You will receive credit for any and all time that you have served. Ms. Garcia, my docket reflects that at the time of the printing of the document, he had 127 days. So I believe you are time served, Mr. Ariola. Is there anything further, Ms. Garcia?
Nothing further, Your Honor.
Mr. Garcia.
Nothing from the state, Your Honor.
Thank you very much. Thank you, Mr. Ariola.
Thank you, Your Honor.
Yeah, if you don't have anything else, you're excused.
Thank you, Judge.
Take care. On Mr.
Annex.
Valdez's case, sorry, go ahead, Mr. Nunez.
I'm sorry, Annex, should we get Valdez, please?
Can we confirm that we received also the written waiver on the in-person? I didn't check that one.
For Mr. Ariola, Judge?
No, for Mr. I know Ariola we did. I need the one for Anthony Valdez. Mr. Huffman, is that your client?
Yeah, let me see, Judge.
I mean, I can look it up, but it'll take this.
Anthony Valdez is my client, Judge.
It's there, Judge.
Okay, beautiful. Thank you. All right, so we just need Anthony Valdez then. After Anthony Valdez, we'll go to Mr. Escobar's client, Mr. Vigil.
Yes, ma'am.
Thank you.
Annex?
Yes, he's coming out.
Thank you.
I'm with you being the owner. It's in the yellow. Move forward.
Mr. Valdez, is that you?
Yes, it is.
Okay. Calling cause number 2024-0D04053, State of Texas versus Anthony Valdez. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Huffman, on behalf of Mr. Valdez.
For purposes of the records, Mr. Valdez is appearing remotely from the jail annex. Mr. Valdez, I need to confirm with you, I did receive a written authorization to conduct this over Zoom rather than in person. Did you sign that?
Correct.
Okay, so let's get started with your plea. Please raise your right hand as best as you can. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Go ahead and put your hand down. Would you state your name and date of birth for the record?
Anthony Valdez, date of birth 07/23/1988.
Mr. Valdez, as I mentioned, I received documents from your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Do you recall reviewing State's Exhibit number 1 with your attorney before you signed that document?
Correct.
Did you understand everything contained within that document?
Yes.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, Your Honor.
Mr. Valdez, are you satisfied with your attorney's representation of you?
Correct.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Valdez, have you ever been found mentally incompetent by any court?
Negative.
I'm sorry, what was that?
Negative. No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a US citizen?
Yes.
Where were you born?
Paso, Texas.
I'm sorry, where was that?
Paso, Texas.
Okay. In this case, you're charged by indictment with unauthorized use of a vehicle. To that charge, what is your plea, guilty or not guilty? Did you hear me, Mr. Valdez?
Guilty.
I'm sorry, you said guilty?
Yes.
Are you making your plea freely and voluntarily?
Yes.
I will find you are making your plea freely and voluntarily. Mr. Garcia, would you summarize the evidence, please?
Yes, Your Honor. Had the state of Texas proceeded to trial, the state would have shown beyond a reasonable doubt that on or about the 8th day of May, 2024, in the county of El Paso, state of Texas, Anthony Valdez did then and there intentionally or knowingly operate a motor-propelled vehicle to wit an automobile without the effective consent of Jesus Marquez, the owner thereof. The owner of the state would like to offer into evidence states 1, the plea agreement, and states 2, Article 3914.
No objection?
No objection, Your Honor.
States exhibits 1 and 2 are admitted. What is the plea agreement?
Your Honor, the plea agreement is pursuant to Article 1244B, credit for all time served.
Mr. Huffman, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
And Mr. Valdez, is that your understanding as well?
Correct.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled the Trial Court Certification of Your Right to Appeal. It's a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Valdez, do you recall reviewing the trial court certification with your attorney before you signed that document?
Yes.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of unauthorized use of a vehicle and I will sentence you according to the plea agreement and in accordance with 1244B of the Texas Penal Code to 31 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Anything further, Mr. Garcia?
Nothing further from the state, Your Honor.
Mr. Huffman?
No, Your Honor.
Thank you, Mr. Valdez.
Thank you.
Now we will go to Joshua Vigil. Mr. Valdez?
And did you got my note right, correct, Judge, that I subbed in for Jesus?
I did see that earlier. Yes, and I think it's already updated and everything.
Yes, ma'am.
Yeah, no. It worked out. Well, that's a much different report than I think the other one I read. Okay. Calling cause number 2023-0D02499, State of Texas versus Joshua Vigil. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Peter Escobar on behalf of Mr. Vigil, Judge, and we are ready.
And Mr. Vigil is appearing remotely from the jail annex. We're set for a bond hearing. Mr. Escobar, you may proceed.
Yes, ma'am. The prior lawyer, Mr. Jesus Olivas, had filed a motion to set bond, and I'm relying on that motion in this court, at this hearing, Judge. My client's on deferred probation. He pled back in October of 2023. And it's my understanding that he was taken out of the TAP program in August or September, and that's when he stopped reporting to the probation department. And so that's a violation. That's why he's in jail. My client did turn himself into the probation department and to Mr. Heras, his probation officer, in January. So he voluntarily submitted to the court. I would ask the court to take that into consideration. Joshua has suffered from depression for the longest time, Judge, and some issues came up in his life personally. He has another child. He's a 3-year-old, but he just had another child. But more importantly, his mother was diagnosed with cancer. And she's going through chemo right now. So Joshua is working 2 jobs, and he tells me that he had trouble coping with his mental illness during this time, and that's why he didn't report. He understands he made a big mistake. He's written me notes, and I've talked to him personally. I talked to Mr. Hedas, and Mr. Hedas tells me that the department is willing to work with him and get him back on the right track.
Was he on the mental health caseload?
No, ma'am, I don't think he is. And that might be a good idea because that is a problem he has. And so I'm asking the court to set a PR bond. I'm not sure in this case where there can be 100% PR bond or not, considering the charge. If not, then I would ask the court to set a very low cash surety bond. Again, the family's rallying around his mother, who's right in the midst of chemotherapy. And so a low cash bond, if the court can't see fit to grant a whole PR bond, allow him to start reporting. Mr. Hedges had no objection to that. Set his case for a status hearing and frequently to see how he's doing, Judge, and that's my request.
Okay. All right. Mr. Garcia.
Yes, Judge, a couple of things. So, first, I'm not seeing is there a motion filed for this bond hearing? I don't think I see it.
There's not. Oh, yes, the motion to set bond. Yes, Jesus did that.
Yes.
There are. I thought I saw it twice if I.
I saw one from Jesus Olivas.
Correct. He was a lawyer before me.
Okay.
Mr. Garcia,
And do we know what the bond is currently set at? Do we know?
it's not set.
No bond. He's in on the bench warrant.
Okay. Well, Judge, I am opposed to a complete 100% full PR bond for a couple of reasons. First, as Mr. Escobar stated, his client was placed on probation on October 10th, 2023. Since then, he was dropped from the TAP program for not attending. He also failed to report to probation on December 23rd, on December 2023, January 2024, April 2024, and all the way through December 2024. So the state will argue that his client is a flight risk, Your Honor. For those reasons, we are opposed to a full PR bond, Judge. We would recommend a bond of $70,000 cash surety.
May I respond, Judge?
Yes.
Yes, my client never changed addresses. I think during that period when non-reporting, he let Mr. Hedges know at least one time that he was still in the jurisdiction of the court. He didn't flee the jurisdiction of the court. He stayed at the same address at 509 Barnhart here in El Paso, and asking the court again for a PR bond. And that's where he will reside with his family.
May I reply, Judge?
Yes, sir.
Yes, he may have stayed in the same address, and even though he knew he was on probation, he still failed to report, which was part of his conditions when he agreed to be on probation. He may have stayed within the jurisdiction in his known address. He knew he was on probation, and yet he still failed to report. For those reasons, Your Honor, we do believe he is a flight risk for not reporting to probation.
So I'm looking at the, let me just confirm with Carla. Carla, there was no eval or recommendation on the mental health end. I'm seeing the 1622 from from his booking, I guess, at the beginning of January. Doesn't indicate there's any mental health concerns. So is he receiving some type of services, Mr. Escobar?
I don't believe he was, Judge.
Well, there's
Your
no.
Honor, if I may, I did check the initial conditions of probation and there was nothing ordered as far as for him to be screened.
And they're not finding anything on the 1622. I mean, are you aware, Mr. Escobar, that he is receiving some type of treatment?
Yes, ma'am. From the very early part of his life.
Okay, where does he receive services, like at EHN or where?
Very sporadic services, Judge.
Okay. Let me see. I do not have a motion yet, right? Miss from the state.
There is no motion, Your Honor.
And he pled to 5 years?
Yes, ma'am. 5 years deferred.
I defer, Your Honor, yes.
The recommendation for Mr. Eras is to continue him with a TAP assessment, right?
That is correct.
Mm-hmm.
The state would like to revoke, Your Honor.
Okay. He has no priors, right?
No, ma'am. And he committed no offenses while on probation.
He was given $500 credit on court costs. He paid it. Does he work, Mr. Escobar?
Yes, he does, Judge. He works at the same place he worked when he was on probation at a tattoo parlor during the day. He's been employed there for a long time. But he also got another part-time job working a door at a restaurant bar in the Cincinnati area.
Well, that's not good.
It's not good. I know. I did not know about it. I told him that was probably not going to be able to continue. And so he told me he'll be looking for other employment because he does need to work 2 jobs. He has 2 children.
Okay, but I have a year's worth of failures to report, which for my purposes, so that your client is aware, that's enough to tell me he doesn't want to be on probation.
Yes, ma'am. Well, he tells me he does, Judge. I think if he gets back on probation, starts reporting, I think you will see improvement with him. Especially if he gets some mental health services.
Mr. Eras isn't telling me anything about any mental health either. Okay. So for now, what we're going to do is he's entitled to a bond. I'm going to set his bond at 50,000 cash surety. We need to set him for a pre-revocation hearing in, let's see, we're the 21st. Or, oh, wrong month. For the 4th of February at 3 p.m. I'm assuming your client doesn't have, he may not bond out. So we'll do it pre-revo 3 p.m. on February 4th. Miss Pineda, if you can ask Mr. Eras to give you some feedback on the mental health angle, being that I'm not seeing it here. Mr. Escobar, and so the state knows as well, I'm not averse to keeping him on probation, but I don't have anything tangible, not to say that your word is not tangible, Mr. Escobar.
No, I understand.
About the mental, like I need a little more specificity if I'm going to really be considering that. At the very least, because the recommendation from probation is to continue, he's looking at the very least at a jail commitment, which I take him to be doing. And an extension. And then possibly we'll review him for
Yes, ma'am.
anything that is impeding.
Yes, ma'am. I think a jail commitment would be appropriate, and I guess we'll just take that up on February 4th. Is that what the court wants to do?
Yes, sir.
Yes, that's what we'll do. And then Judge,
So
is that
your
gonna be by
client
Zoom?
knows, Mr. Escobar, if we do that, there's none of this working at Cincinnati, all of that business.
Yes,
So
yes, ma'am. I understand.
go ahead, Mr. Escobar, you were gonna
No,
say?
is it going to be by Zoom or in person, Judge?
It's in Zoom, I'm assuming, because he'll probably still be in custody,
Okay.
doing it on the jail docket. Okay?
Yes, ma'am. Thank you.
Ándale pues. Thank you very much. That's the order.
Yes, I'll be in touch, Joshua.
Thank you.
Judge, may I be excused?
You may have a good day.
Okay.
Let's go to Mr. Montoya's case, Megan Tiller.
Good afternoon.
Good afternoon. Let me just pull up her summary. Oh, does she have a summary? Calling cause number 2024-0D05010, State of Texas versus Megan Tiller. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Roger Montoya for Megan Tiller. We're ready to proceed, Your Honor.
And for purposes of the record, Ms. Tiller is appearing remotely from the jail annex. We are scheduled for a bond hearing. Mr. Montoya, you may proceed.
13 trucking.
Thank you, Your Honor.
Yeah, tell me get ready and we'll be
My
there.
client, Megan Tiller.
Hold on a second.
Was-
Annex, I'm going to go ahead and mute you briefly. Mr. Montoya, let me know because there's some background noise if you need your client's assistance, okay?
Thank you, Judge.
Thank you. Go ahead.
My client was born in Carlsbad, New Mexico, which makes her a United States citizen by birth. She has an opportunity for employment. I will have to ask her though if it's still the same one.
Okay.
Last time it was Envision Home Healthcare. She was a healthcare provider, home healthcare provider. The last time I spoke with her, and I can verify that with her in a moment.
Mhm.
I do believe that she has a stable address to stay. She can provide us with that as well. A gentleman by the name of Harry Hatton, who appears to be a very close friend of hers, has been in touch with me and assures me that he would be willing to help her with whatever she might need. I don't believe my client to be a flight risk, Your Honor. I don't think she ever left the jurisdiction. I just think that she had some very serious problems with finding a stable address, and then she also had trouble with maintaining a reliable phone connection. And so I think that if she were released, she would solve those problems and avail herself of both the court and the PR bond office and maintain contact with them. Your Honor, my client is truly indigent. She does not have sufficient funds for a bond. The current bond is $100,000, and I believe that's for a failure to appear before this court. But again, I think the explanation there is that she's just had difficulties with maintaining communication, which I think she will resolve upon release. And I'd like to ask my client if we could go ahead and unmute her.
Okay, Annex, if you would please unmute. Does she still have an outstanding fugitive warrant out of Alamogordo?
Oh, that's a good question. I wouldn't know, Judge.
Okay, go ahead.
Ms. Tiller, are you still, if you were to be released, going to be employed at Envision Home Health Care of El Paso?
I am taking care of a lady by the name of Miriam Smith. Yes,
Hold on, if you're gonna be asking her questions, let me swear in real quick. Ma'am, raise your right hand. Do you swear or affirm that any testimony you provide will be the truth and the whole truth, Ms. Tiller?
yes, ma'am.
Thank you very much. Go ahead, Mr. Montoya.
So under oath now, you will be telling this court that you will be working as a home health care provider if you are released,
Yes,
and you will be making every effort that you have to in order to maintain contact with the court's supervisory arm, the PR bond department,
yes,
and
sir.
with myself.
Yes,
And do you have a stable address where you will be staying?
3301 to the Rosa Avenue.
Okay, that's the last address I had for you.
Yes, and it is taken care of. It'll be a stable address.
Whose
Okay.
address is that?
Excuse me?
Mr. Montoya, whose address is that?
Miss Tiller, is that Mr. Harry Hatton's address?
Yes, that's where he stays. Yes.
And Harry Hatton is a friend of yours?
Yes, and he's been paying rent there and been staying there even since I've been locked up.
Very good. I passed the witness, Your Honor.
Mr. Garcia, you have any questions?
No questions from the state, Your Honor.
Thank you very much. Mr. Montoya, go ahead.
Thank you, Your Honor. Yes, we'll be asking the court for a PR bond in this case. As I said before, my client is without funds to pay a bond in this case. And that is my motion, Your Honor.
Okay, give me a second.
Mr. Montoya?
Ma'am, you need to not speak until the court gives you permission, okay?
Is there a co-defendant in this case?
Yes, Your Honor.
Who is it?
His name is, one second, it is Jose, I'm sorry, no. He's not listed here, but there is another offender. Let me see.
Okay, in terms of just so I'm clear with you, Mr. Montoya, looking at the PSR, the prior history, it does show 2001 Carlsbad battery against a household member. 2000, then we go all the way to 2013. We got a couple of shoplifting, Roswell, contempt of court. Doesn't give an underlying. In 2013, some kind of petty misdemeanor in Carlsbad. In 2014, we go to Artesia, failure to appear. Then in 2014 in Eddy County, New Mexico. It looks like some of these are with respect to public assistance and maybe some allegations of just failure to disclose facts on some of those. So there's a few entries there. Yeah. Yeah, some entries on public assistance, false claim for reimbursement. Let's see today. Then in 2015, I have a probation violation out of Eddy County. And then that's what gets me to, oh, these are some of the bond conditions here. Is there a connect to Bell Elementary? Does she have children? Do they go to school there? No?
Not that I know of, Your Honor.
Okay. Then we have this one, burglary of building. I think that's where we have our Bell Elementary connect. But the last entry in her PSR is the one on Alamogordo. Confirmed that she has a warrant outstanding, Alamogordo, contempt of court, failure to appear on a misdemeanor, 2/24/2023. That's all it says. All right, so let me check something.
I'm checking the police report, Judge, in terms of, there's a section involved persons.
Uh-huh,
As 12 offenders, she's the only one listed.
okay. What's the legislative offense on this case?
It is August 1st, 2024.
Okay. Yeah, she's not going to be able to stay with Harry Hatton. Yeah, does he live there at that residence?
He does reside there.
Okay. So he was just indicted for fentanyl. So that's not going to happen on December 11th.
And Your Honor, if I may, on the report, Ms. Tiller does admit to being a drug user of fentanyl as well.
All right. I'll hear from you, Mr. Garcia. Go ahead.
Yes, Judge. So the state is not opposed to a reduction of the bond. I do believe 100,000 is a bit excessive for this case. I will defer to the judgment of the court to see if they will give her the full PR, Judge. Aside from the history that the court already mentioned, the only thing alarming to the state is, of course, the use of fentanyl, Judge. The state will encourage them to take the plea offer and for her to receive some drug treatment. Other than that, Your Honor, the state is not entirely opposed to a reduction.
All right. Anything else, Mr. Montoya?
The court might, if taken everything that Mr. Garcia is saying is true, then I don't see that we would have any objection, of course, to the court adding some sort of rehabilitative services to the conditions of bond. I'm sure my client.
Perdón, Mr. Montoya, how long has she lived in El Paso?
Well, that's a good question. I really wouldn't, you know what? That's not something I asked her.
Going on 2 years, Your Honor.
2 years?
Yes.
So Alamogordo has you outstanding since, what is it, 2023? Do you see that on there, Marissa? Is there any kind of hold on her? Anything regarding, I didn't see that in the booking, but it's on her PSR.
There's not an active hold, Your Honor.
Okay. Okay. All right. So, yeah, I'm not comfortable with any of a lot of, I guess, the conditions, Mr. Montoya. I don't think those are gonna be real useful. So, but I am gonna grant your request to lower bond. Her bond is high. She failed to appear. She has a history of failing to appear, and I would probably be okay surmising that some of her prior history has to do with drug use. So we're going to, but the allegation is that she and another individual whose name I do not know, I don't see there being a co-defendant, were in Bell Elementary. So I think that's where the prior conditions are there. She's gonna have a $25,000 split bond, 20,000 cash surety, 5,000 PR, remain in El Paso County. She is not to live with or have any association with Harry Hatton or whoever this co-defendant is in this case, whoever, I'm maybe not calling him a co-defendant, but witness in the underlying case, appear for all court settings, subject to testing, curfew, 9 p.m. to 6 a.m. unless she is working. She is to be tested bi-weekly. Yeah, not leave El Paso County, maintain her contact information with pretrial services. Any other conditions, Mr. Garcia?
No, Your Honor.
Mr. Montoya, I'm trying to see, she has a setting already next week, pretrial 2801, and then we get to a jury trial in May. Ms. Nieto, what were you gonna say?
Reporting, is that in person or by phone? Her previous conditions were by phone.
In person.
That was it, Your Honor.
Okay. All right, and in terms of the failures to appear, the way we got here, was it just one? Go back and look. That's the order.
I don't, my notes only show one, Your Honor, back in September of 24. And Your Honor, one thing that I would ask the court to reconsider is that amount of the cash corporate surety portion of the bond. You know, at 20,000, any bonding company is gonna require collateral for the full amount. If we could get that to 10,000 or less, she could bond out with cash and then wouldn't be required to put up collateral, which I'm sure she does not have.
No, I mean, the bond reflects the court's concerns about her going missing again. Okay,
Very good, Your Honor.
thank you very much. Thank you, Ms. Tiller. All right, I guess we'll go up the list to Miguel or Jesus Miguel Silvas, if Mr. Parra, he's been here.
Hello, Your Honor.
Howdy.
But
Are we really almost done? Wow.
You sign?
what's the name of it?
Silvas?
Jesus Silvas.
Is it 13?
I feel like I haven't seen you this year, Mr. Parra, have I?
I
Maybe.
don't think so, Judge.
Yeah, it feels weird. All right. A ver, Silvas.
Your Honor, I'm trying to find out if Your Honor was on the bench December 12th when we last had a hearing on.
I think. Oh, I couldn't tell you. That's the wrong calendar. I feel like no. But
Okay.
I have to look at the.
Those are my thoughts too, Judge. I just wasn't sure. I don't want to bore you with unnecessary background.
Let's see, motion substitute. I want to say that's when I was out, and it might have been Judge Sheila.
Judge, we had Judge Alcala on the bench.
Yes.
That's right.
Okay.
That's right. Thank you, ma'am.
Okay, but the notes say that it was set for a contested revo. I knew.
Judge, well,
Your Honor,
Yes.
the notes I have here is that on the case 4211, the judge did set one case. He did give a grant a bond on one of the cases.
Mhm.
The rec from the state was 5 TDC on the second and third degrees in 12 months. On the state jail, they couldn't come to an agreement, so the judge set it for a contested revo.
that's what it was, Your Honor. And Judge, and thank you, Ms. Santo, for reminding me about that as well, Judge. This case was set. He picked up, Judge, 2 misdemeanors of resisting and evading an arrest, and thought it a good idea. Apparently was advised that it was okay to plead guilty to time served, Judge, essentially proving some of the allegations in the motion to adjudicate, Judge. I had intended at the last hearing to approach you, Judge, about perhaps treating his time in custody at that point as a commitment, Judge. He's been in custody for 145 days as of today. He's essentially got arrested for evading, pled out, got out, and then was arrested August 29th, Judge, and has been in custody since then. But in reading the motion to adjudicate guilt, he was doing well on probation and then goes and pleads guilty to this. I wish he hadn't, Judge, but I guess what I'm asking is that Your Honor treat this as a 145-day commitment and allow him to remain on probation. Mr. Garcia, I know you're new to this case as well.
Right, and I read the summary. I'm not entirely convinced, but
I have him.
Convinced of what, to be sure?
that he was doing well on probation. I mean, he
I
pled
see.
one and then picked up a couple of cases afterwards. He failed. He was dismissed from the anger management class twice for non-attendance. So I have my
Right, Judge. He was also behind on some community service, Judge, but I think really the bulk of it goes to the July 8th offenses. That's when he gets arrested for evading arrest and resisting arrest, Judge. I wish he hadn't pled. Now he has those 2 convictions and additional 145 days in jail, Judge. I'm not sure that TDC would do him any good, and I think he's definitely had time to reflect both on his decision to plead guilty and his picking up the new cases.
Okay, 2020, 2012. 2013. Has he been to prison before?
Uh,
I don't believe he has, Your Honor. I'll check on that.
I'm checking, Judge. I don't think so.
I don't think so either. Let me go back to the.
He has not, Your Honor.
He's been to the county many times, but
Yeah, I was going
I
through the
wouldn't say
jailings.
many. I'd say a few times.
He's got a few jailings, like you could say many, but his PSR is much bigger. So let me see what's here.
And Judge, it doesn't look that any of the times that he's been in custody for the misdemeanors has even come close to 145 days. He had a 45-day sentence in 2013, which I imagine he did somewhere closer to 30.
Yeah.
Well,
Poor Judge Alcala, I left him some convoluted cases. Let me see.
Any thoughts? Ahorita que carrera eléctrica y tú en la 40% and one way you're doing another one. No, you're terminando, so they should be over there in the transport. Okay. Okay, thank you. Yes, sir. Let's see. The thing though, sometimes like. And it's gone to the other gates we want them to. So.
Is Mr. Silva's at the annex?
Yes, Your Honor.
Okay, if we could have him, please.
Yes, he's coming out, so this.
Thank you. So we did a bond hearing in October. And I denied all of those bonds.
And I believe I came in sometime in December, Judge.
Yeah. Thing. Yeah, so he just keeps racking up cases, but let me. While he's on probation.
Judge, outside of these two, are you seeing any others? I don't
We
believe that I can see.
I think we had, well, I can go back to the older, I'm looking at the most, I'll say the most recent summary. The summary I'm looking at is back from October 15th. And I just want to go through, he's unsuccessfully discharged. What I'm looking for in some of these prior, and then let me go go back one more. So if I look at, I got so many screens open here. It's silly. All right, so we've had a few motions on him for picking up all new arrests, right? I mean, no, new offenses. So he was referred to anger management, failed to report September. We regained supervision. This is September 2021, regained on October 2021. He was rearrested in 2022. That's some of the cases we have here on an A of V, the victim brother-in-law, assault in a public service, both were scheduled for plea in 2023, then a violation notice. Well, this is back in 2022. Start anger management in 23, did not provide proof of enrollment. No MHI placement. We got 2 new cases. Those are the ones that we added to his probation. He was already on probation for 2 cases. Where that one ends. I mean, he just keeps picking up new cases, right, Mr. Parra? I get into the misdemeanors, but
It's these misdemeanors, Judge. I wish he hadn't pled to, but I mean, essentially, with the time that he spent in custody because of this misdemeanors, he might as well have pled to the maximum on them, Judge. And that's what I'm asking the court to consider, Judge, is perhaps treat this as a commitment. He did pick up these cases, Judge, and I'm sorry for misspeaking earlier as to the other cases that he had picked up while on probation, Judge. But I was going off of the most recent motion to adjudicate guilt, which doesn't speak to those, Your Honor. However, with respect to the new ones, again, Judge, I'm not sure why he decided to plead guilty, but shortly after that, he ended up back in custody. Mr. Sivas, you weren't here for this part, but we were discussing pretty much the background of the arrest and the fact that you've been in custody since August 29th. Your Honor, I'm asking that this be treated as a commitment again, Mr. Sivas, in spite of having done some time in misdemeanors before, Judge. I don't believe that he's done anything approaching this or approximating this. And he has very much, Judge, realized that it was a mistake not only to plead to those cases, but to leave everything else pending. He did speak to me, Judge, as about the anger management, Judge, and expressed to me that for a while. And when Your Honor mentioned no MHI, Judge, I have reason to believe there might be something there, Judge. He did describe to me that he was going through some very emotional and difficult times, Judge. And what he described to me, Your Honor, I think does rise to the level perhaps of requiring some kind of evaluation, not with respect to competency, but definitely I think he would benefit from some counseling, Judge. He did mention to me, Your Honor, that well, he's a member of the Tigua tribe, Judge, and he describes himself as a shaman, and apparently some experiences that along those lines contributed to his having a really difficult time around this time and his missing the anger management classes, Judge. However, he does intend to get back on track. What I would be requesting, Your Honor, is that you would consider leaving him on bond, perhaps reset the contested revocation. I do believe that we should have had at least one more pre-revocation in between. Give him time to catch up on what he needs to. And again, Your Honor, still leave this motion pending. Hopefully, Your Honor, at the end of all that, he shows the court how serious he is about completing the conditions and complying with probation, Judge, at which point we can treat the 145 days as a commitment and perhaps even modify him.
Yeah, okay.
Your
No,
Honor.
no,
Yes, Your
I'm
Honor.
not gonna keep him on probation. What I frankly was looking for on these case summaries was, had we already discussed a number? So so Mr. Silvas understands you should be less concerned about the fact of whether you pled or you didn't plead on some misdemeanors and more concerned about the fact that you keep picking up cases while you're on probation. See, that's the whole point. You're not supposed to pick them up. You're supposed to follow all the conditions. So we have a contested revocation set for Thursday, if I'm not mistaken.
That's correct, Judge.
That's correct, Your Honor.
All right, so are these on, in terms of the bond, I gotta assume, Mr. Parra, he's on no bond on all of these? Is that right?
Judge, I was showing that I'm getting mixed information. I'm showing on the one hand 25,000, and I was seeing that there was no bond on it.
Let me double check the jailing.
However, Judge, we would request that if there is not a bond, that you set one, and if there is 25,000, that you lower that bond.
Yeah.
Judge, of course, I haven't got into the bond hearing part of it, but if you would like any of his background, I'd be happy to share that as well.
Okay, so I'm seeing, I assumed they were no bonds, but yeah, Marissa, if you'll confirm for me, I'm sure I'm seeing now 2021 case 25,000 and each of the 2022s. I'm sorry. One is at 20 and one is at 25,000.
Yes, Your Honor. Those were reduced September 10th.
Okay. By me, right?
Yes, Judge.
Okay. All right, Mr. Barra. And I'm sorry, Walter, I hope have you been taking this down by any chance? I know I hadn't called it yet.
I did not, Judge. You didn't call it.
That's okay. I'll call it now. Calling cause numbers 2021 0D00055, 2022 0D00195, and 2022 0D0. I cannot see without these glasses today. 0875, each case style, the state of Texas versus Jesus Silvas. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Manuel Parra, Your Honor, Mr. Silvas.
And for purposes of the record, Mr. Silvas is appearing remotely from the jail annex. We were discussing extensively off the record, Mr. Silvas' circumstances. He was here for part of that, Mr. Parra, not all of that. So let's just start from the beginning. We're set for bond hearings here. You may proceed.
Thank you, Your Honor. Judge, if I may, I don't know if you would want me to repeat any of the background for the record.
Anything you want on the record, please state it.
Understood. Your Honor, for background purposes, Mr. Silvas had approached this court in December after retaining me, Judge, and after I substituted into the case. He had been arrested for evading arrest and resisting arrest August 29th while on probation for these matters, Judge. Pled guilty to those, entered a plea of guilty to the sentence of time served, and of course, those convictions, or rather those offenses are alleged in the most recent motion to adjudicate guilt. Your Honor, we had requested at the time that Judge Alcala, who was covering for you that day, consider a commitment of sorts, Judge, and we were then set for a contested revocation, and that is set later this week. Your Honor, my client has been in custody at this point as of this arrest for 145 days in jail, Judge. I mentioned earlier that had he pled to the maximum on the misdemeanors, this is what he might be looking at. In the alternative of a bond reduction, Judge, I'm asking that the court consider this as a commitment and allow Mr. Silvas to stay on probation. With respect to the bond hearing, Judge, a little bit of background with respect to his ties to El Paso. He has lived in El Paso all of his life, was born here. He is a member of the Tigo tribe, Judge. It's my understanding would still have employment available to him. He was working, doing landscaping with the tribe. And it's my understanding that he would have that available to him and would also have a position available if the court would allow him to work there at Speaking Rock. She doesn't have any children, does have a wife. He says common law marriage, however, would be living with his mother if he were to be released. I believe the court has the address of 9341 Naquitu. This is on the reservation, Judge. And Your Honor, in addition to what he actually works as for income, he is a medicine man of sorts within his tribe and helps several people in that regard. Judge, I'd be asking that Your Honor consider a reduction of his bond that would allow for his release such that he's able to at least comply with the remaining conditions of probation while Your Honor considers the disposition of his probation cases.
Thank you, Mr. Parra. Mr. Garcia.
Yes, Your Honor, briefly. So the state has a concern about Mr. Silvas. Your Honor, I believe condition A of probation is no new offenses against the state of Texas. Ever since Mr. Silvas was placed on probation in 2021, he has since then pleaded guilty to one assault family violence in 2023. And then he pled again to an evading arrest in 2024. Your Honor, there is a pattern of reoffending. The state has is alarmed by the fact that Mr. Silvas is, if released, he'll be reoffending again. Your Honor, aside from that, he has not completed the terms of his probation. He has failed to complete the anger management class. He has failed to complete the hours of community service. He has failed to pay his court costs and fees. Your Honor, the state does not believe he is a good candidate for probation. For those reasons, Your Honor, the state will be opposed to any bond reduction.
Mr. Parra, anything else? Well, let me go through just so I did want to review. We probably went over this off the record that his bond had been reduced by me back in September, so that on cause number ending 4211, he's at 10,000 corporate cash corporate surety, reduced from no bond. Same on cause number ending 0055, he's at 25,000 cash surety. Again, from no bond, that's on an ag assault. The previous one is on a theft with 2 or more previous convictions. And then we have an assault, family violence from no bond to 20,000. 875, assault on a public servant. You know, these are all, he's at $25,000 there. If I go outside of the jailings and I go through his PSR, we start in 2004. I won't go over those, but then soon after that, it's a 17-page PSR. So not only am I relying on the fact that he reoffends while he's on probation, he has an extensive criminal history, and let's go over that history. County Court 7 in 2013, let's see, that's a theft. Then we have a criminal trespass, guilty. 2014, assault, family violence was a felony. They reduced it to a misdemeanor out of the 409th. In 2014, he did 150 days there, the same that you're asking me for a jail commitment right now. And then we got some drug charges, same booking, convicted, reduced. So you got another chance, Mr. Silvas. And then in 2016, ag assault, family. Let me find out where that was. First degree, that was in the 171st. They dismissed that in 2017. Let me see. And an impeding in 2016, no disposition there. And then let's see, in 2019, is that where you start with me? No, you pick up a Class C theft in 2018. 2019, you got thefts with previous convictions. So it tells me you already have a history. CCR 4, guilty, 25 days. Do you think he's learned his lesson, Mr. Parra? That's rhetorical.
Yes.
Okay. All right. Your request is denied.
And genuinely, Your Honor, of course, you know, it's not just in the spirit of advocacy, but in speaking to him, Judge, it's been clear to me that he hasn't faced these consequences this time in custody, had an opportunity to reflect on what he hasn't done, what he was supposed to do, Judge. And so frankly,
he didn't reflect all the other times he's been in jail since 2012? No. Your request to reduce bond is denied. We'll see you on Thursday for your contested rebel.
Understood.
Thank you. Let us know if you
Yes,
have,
we'll be in touch, sir.
if
Thank
you have a schedule change, Mr. Pop.
Understood, Your Honor.
Thank you. Who's
Thank you,
next? I show a Mr. Ponce, Jose Ponce.
Yes, ma'am, for Mr. Huffman.
Uh-huh.
Next, could we have Mr. Ponce?
Yes, he's coming out.
I guess, are they both yours, Mr. Huffman?
They
Ponce
are, Your Honor.
And Ramirez? Okay. On Mr. Ponce, he has a criminal mischief as well, right? 2024-0D07931, but that one he's on PR bond, is that right?
He does have that new criminal mischief, Judge.
Uh-huh. But that's a $5,000 PR bond, right?
Is it? I thought it was a $5,000 surety, but I'm not sure, Judge.
Let me go look. I thought Judge Nunez and the jail magistrate gave him a PR bond recently. So let me see. Ponce.
Yes, Your Honor.
Okay. So all I have is the A of V, right? Okay. All right. Calling cause number 2024-0D04783, State of Texas versus Jose Manuel Ponce. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Huffman on behalf of Mr. Ponce, we're ready.
For purposes of the record, Mr. Ponce is appearing remotely from the jail annex. We are scheduled for a bond hearing today. It looks like his trial is in May. This on an assault, family violence. I did not notate his bond. You may proceed, Mr. Huffman.
Thank you, Your Honor. Mr. Ponce, Judge, is in custody on a $100,000 bond for this case. He's been in custody for 20 days.
Mm-hmm.
Judge, he's a United States citizen, a graduate from Andress. He works at a pool service company called Four Seasons Pools.
Mm-hmm.
Judge, it's my understanding that he does not have any adult convictions on his record. He does have a 2-year-old, Judge, that he helps out. He pays child support. Your Honor, the thing I found kind of disturbing about kind of what happened, Judge, is the bond company that he's been using to bond out. They filed an affidavit of incarceration after they bonded him out. They filed an affidavit of incarceration like the next day. So I found that kind of interesting.
Okay.
Your Honor, he, like I said, he has no criminal history. We aren't set for a trial until May. He does. We don't have an offer yet from the state. He does. I mean, I think probation might be a reasonable outcome, but he does look forward to his jury trial, Judge. He promises to appear in court. He promises to stay away from the complaining witness, Ms. Lizardo. Judge,
What's the relation there, Mr. Huffman?
it's an ex-girlfriend, Your Honor.
Okay. Mm-hmm.
I've spoke. He lives with his grandparents, Your Honor, here in El Paso.
Mm-hmm.
I've spoken to them, and they're retired, Judge. They get Social Security, so they have a very limited income. They might be able to afford a $5,000 surety bond.
Mm-hmm.
And we're asking the court to reduce the bond, Your Honor. He cannot afford the $100,000 bond. Judge, like I said, he promises to comply with conditions of his bond, and he promises to appear in court. That's all I have, Your Honor.
Okay. Mr. Garcia?
Yes, Your Honor. For this case, so we did speak with the complaining witness. She is very, very scared of the defendant, Your Honor. I'll brief the court of the facts of what happened in this case. It is alleged that the offender arrived to the home and physically assaulted the complaining witness by covering her mouth, impeding her breath for a couple of seconds. He then threw her onto the ground, wrapped his shirt around her head, and threw her inside a closet. He kept her there inside the closet. After the complaining witness attempted to flee, he threw her to the ground again and prevented her from leaving. Your Honor, she is scared of the defendant. She does not want him to go near her. She is afraid that if he is released, he will go near her. Your Honor, Maybe we will offer probation. I'm not entirely sure at this point. I don't have a recommendation. Aside from the fact that, Your Honor, after he picked up this case, the assault, he did pick up another case. As the court mentioned, he picked up a criminal mischief in December. The date of the impeding breath of the case at hand is May. So, Your Honor, the state has concerns that Mr. Ponce is a danger to the community as far as a danger to the complaining witness in this case. Your Honor, for those reasons, the state believes that the 100K bond is reasonable.
And Judge, if I could briefly respond
Yes, sir.
as far as the alleged facts of the case. My client denies the allegation, denies he ever impeded her breath. Actually, my client says that she would not give him his keys, that he was trying to leave the house. She would not give him his keys. She was upset because he had deleted games on the PlayStation. So he completely denies any kind of choking or impeding breath. She was screaming, and he told her to be quiet, but that's the farthest he got as far as impeding her breath. So he's denying these allegations, Judge.
All right, so I'm clear the unlawful restraint that shows up in his PSR, there's only one, right? Because I see a jailing for December, but that might be, I don't know, is it the same one? Here's my concern, part of my concern is the nature. I think you're correct, and I'll double check the PSR as I'm looking at it right now, is that everything that's in his PSR, which isn't huge, 6 pages, is all assaultive and it's all family related, right? We have CCR2, there's an assault there that was dismissed in 2019. Then we come over here, assault family violence, 2021, dismissed in 2022 out of county criminal court number 4. And then in 2024, I think that's when we get the unlawful restraint and my assault family violence impeding. What's in August. And see, and then I see an event cycle for the criminal mischief. Okay, the criminal mischief comes in December. And what was the December criminal mischief? They were fighting over games. It's the same. Is it the same complainant in the assault family violence and the criminal mischief?
It is, Judge. It is.
All right.
And that the criminal mischief, Judge, that involves allegations that he, I guess, got on her hood or something of her vehicle and caused damage to her car.
Okay, so yeah, I'm not, that's not really. They're facts that bring the court concern, right? About the safety of the community, the safety of the complainant. How old is your client, Mr. Huffman?
It's 24, Your Honor.
And we're jumping on hoods? What's going on?
Well, it's obviously a volatile relationship, but I think it's on both sides. But like I said, Judge, he will stay away, 100% stay away from her.
Was there a protective order? Is there an active protective order?
That I don't know, Your Honor.
Yeah. And he's
Judge, we don't know that he will stay away from her. I mean, after the fact that he was arrested for the assault, he was then arrested for the criminal mischief with her same complaining witness.
Yeah. Okay. All right, let me get back over here.
My client also denies that the jumping on the hood. I think
I get it, but look, whether there's, how can I tell you? I don't know what happens there, but the circumstances don't sound great. I'm not saying they're criminal. What I'm saying is, am I going to continue to have problems with your client if I let him out on a lower bond? That's my concern. There's an emergency order for protection, but that's since August, right? So that's expired.
I think there was a possibility of reconciling the relationship, but I think at this point my client understands that it's not in his best interest to get back with her. I don't think she wants to get back together with him.
They're not. They don't share the child, right, Mr. Huffman?
No,
okay.
No, Your Honor.
Okay. All right. Anything else?
Nothing on this day, Your Honor.
Not from the defense here.
The court is going to grant the request to reduce bond. It's going to be a $30,000 split bond, 10,000 cash surety, $20,000 PR. He is to report once a week by phone to the PR bond office. I don't think your client likes it, Mr. Huffman.
It costs $1,000. I'll talk to your grandparents, Mr. Ponce.
Can I just say something?
I don't think so. I don't think it will help, sir. Respectfully.
He is to have no contact with any complainants in these cases. He is not to be within 200 yards of any residences or places of business or school of the complaining witnesses in this case. He is subject to testing as to use no illegal drug or alcohol. He is not to possess any weapons or ammunition. He's to remain in El Paso County and may not change his place of residence without court permission. And my understanding is he's living with grandparents, Mr. Huffman?
That is correct.
Okay. All right. Any other conditions, Mr. Garcia?
No, Your Honor, the state only concern, and the court already addressed it, is no contact with complaining witness, Lisbeth Lizardo, and not going to near her address as well.
And I mean no contact, like no direct, no third party, no sending text to your friend who's going to get in touch with her. If the only, well, that's it. No emails, no nothing. Did you say there is not a rec at this time, Mr. Garcia?
There isn't, Your Honor. I'm sure it's going to involve probation. I just haven't thought of a number, but it's going to be some sort of deferred probation. I'm thinking something along the lines of 5 deferred, no contact, anger management, counseling, all that stuff, Your Honor.
All right. Okay, that's the bond order, Mr. Huffman. Anything else?
No, Your Honor.
Okay, thank you, Mr. Ponce. Annex, if I could now have Daniel Ramirez.
You know, it's out of your.
Mr. Ramirez, is that you?
Done.
Okay, calling cause number 2016-0D00323, State of Texas versus Daniel Ramirez. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Huffman on behalf of Mr. Ramirez, we're ready, Judge.
Did I say that right? 2016-0D00323. Okay. All right. For purposes of the record, Mr. Ramirez is appearing remotely from the jail annex. We're scheduled for a bond hearing. Mr. Huffman, you may proceed.
Thank you, Your Honor. Judge, Mr. Ramirez is 41 years old. He's a longtime resident of El Paso, Judge, a United States citizen, a veteran of the U.S. military. He served in the Air Force, Judge. Your Honor, I'd ask the court to take a look at his criminal history. There's just not a lot there. This is a probation violation, Judge, from a case from 2015. It's a true third. There is just there's no prior arrest for any violent offenses. Despite other than this new arrest for a burglary of building. Judge, since 2000, well, he's been at the same job, Judge, for over 20 years. He works as a licensed journeyman electrician. He's a member of the union, Judge. We've had contact with his employer. They have nothing but good things to say about him. Judge, he currently resides with his fiance here in El Paso. He's lived in the same house, Judge, for about 18 years. His wife has 4 children. They're not his children, but they are very close to him, and he basically has raised them. He is the main breadwinner in that house, Judge. Your Honor, one of I guess the main reason that we're asking this court for a bond, a reasonable bond, is so that Mr. Ramirez can get out and treat his, he has a severe infection that's happened since he's been in custody. He's been in custody for about 52 days, Judge. That condition is getting worse. He has been to the clinic, but they have not done anything to treat that condition. He's very scared, Judge, that might turn into something really bad.
Well,
Your Honor,
Mr. Huffman, I'm looking at his probation summary. He was an absconder since 2021. He's termed.
So he has term, Judge. He's been out. He has not committed even a traffic offense other than, you know, this new allegation. Yeah, I've looked at this new allegation, Judge. I don't have any video, but it's my understanding that this is at a DK gas station, and it's my understanding that the alleged assault is basically a hug that to the DK employee.
Was hugging the DK employee on the burglary of building. Mira, that one brings me less concern. My concern is he's on for a DWI third and he's an absconder.
Your Honor, and I certainly understand that. I've asked Mr. Ramirez about that. Judge, it's my understanding that the probation department just never made any contact with him. Never. He was basically waiting for them to contact him. They didn't do so. Your Honor, he would agree to an alcohol monitoring device for the time being.
Can't do anything with him. Either dismiss the motion or give him prison time.
And I thought about that as well, Judge. And my hope is, Judge, that he could get accepted into the Veterans Court. That's a very intensive probation, minimum 1.5 years probation. I think the court can do that. It's just as easy as just transferring the case to the Veterans Court and allowing him to do that probation. He certainly would be, I think, successful with that. Again, Judge, he agrees to an alcohol monitoring device. We're hoping for just any kind of reasonable bond here, Judge.
All right, for an absconder. All right. Mr. Garcia.
Yes, Your Honor. I'll have to admit that when I first saw the case in the docket, I was very confused as to why we were addressing this case, since he pled so long ago and for only 5 years. But now I understand that he's termed. So, Judge, the only possible resolution here is to either dismiss the case or revoke. Your Honor, as the court mentioned, he's an absconder since 2021. He's clearly a flight risk, Your Honor, and he, of course, did not complete probation in a satisfactory way. He also committed a knee offense, and I'll go over the facts of the knee offense. It's not, the allegations are, and it's not so much of a hug, is that he went behind the counter of the store. He pressed his hands against the complaining witness on her ribs and abdomen, attempted to force a kiss on her. Your Honor, those are the allegations of the knee offense.
Was he intoxicated allegedly? Or
Your Honor, it does not mention any intoxication. It just mentions that he was forcefully trying to force a kiss upon the complaining witness.
Do we know if he was driving?
Let me check, Judge.
And Judge, this is the DK by his house.
No, but here's the problem. He's on probation. It's not so much. I'm not going to sit here and be like, well, true or not, what's happening on the burglary building. My concern is he is somebody who is on probation for a DWI third, a conviction, 5 years probation that he blows off. I'll say about 3 years. He stops in 2021, right?
I think it was 2018, Your Honor.
2018, Your Honor.
Oh, 2018. So he blew off probation. And just like normal. And then, that doesn't happen. That's not going to happen.
Yes, Judge. And to answer your question, Judge, the defendant was at the scene driving a black Mercedes.
Ah, qué abuelo.
And Judge, like I said, it's the same DK that he always goes to. He's very.
Where he buys his beer?
I-
Yeah, I know, Mr. Huffman, I know, but this is the problem. We're gonna revoke his probation. Do whatever you want to do on the criminal, on the burglary of building. He's an absconder. You want time? You want a time number on the probation case? Well, we're not there. We're at the bond hearing. Your request for reducing the bond is denied. He's gone since 2018?
He never left, Judge. He had the
I
same
know, but he
job.
stopped reporting since 2018?
That's the allegation, Your Honor.
And it's 2025, so he had 7 years? Right? Am I doing the math right?
That's correct.
Your
Judge.
Honor, if I may, according to the report, he last reported on 10/31/17.
He blew off probation. He can do 5 years TDC. We need to set the new case if it hasn't already been set for trial. Thank
And
Mande-
respectfully, Judge, I'm gonna staff the case with Mr. Avila from the Veterans Court. I think that's a good option, Judge. I know that the circumstances aren't the best for us, but
Mr. Huffman, I am not gonna, you can staff it. I am not gonna refer him anywhere. I cannot refer him, unless you can tell me differently, I cannot refer him on the DWI case.
No, Judge, he's termed.
Yeah.
well, I think if we're not pleading, we're not extending, we're just simply putting him in the Veterans Court, Your Honor,
Yeah, no.
and
Okay.
keeping the motion to revoke open.
His pre-revo is set for the 28th. I hope you have an answer, or he has decided, he realizes that you don't come in here and plead to 5 years probation and then take 7 years off and expect to just get modified. That doesn't happen. Okay.
Judge, I'm sorry, the 28th is not available.
It's set though, so they can talk about it on that date. That's
Okay,
fine.
yes, ma'am.
Thank you. Anything else?
No,
Nothing to say, Your Honor.
Thank you very much. With that, I think we are adjourned for today. Annex, thank you very much.
Thank you, Your Honor. Can we be excused?